Welcome to the 17th meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. We have apologies today from Pam Gossel, and we have Tess White and Marie McNair joining us online. I'd also like to welcome Paul McLennan, MSP, to his first meeting of his committee, and with that I turn to our first item. And our first item this morning is to invite Paul McLennan, MSP, to declare any relevant interests.
Convener, nothing of relevance to declare this morning.
Okay, thank you. Our second agenda item is to agree to take agenda items 4 to 6 in private. The committee has previously agreed to take items 7 and 8 in private. Agenda item 4 is consideration of the evidence taken by the committee this morning on post-legislative scrutiny and the non-implementation of parts of specific acts of the Scottish Parliament. Are we all agreed? We're all agreed, thank you. Agenda item 5 is consideration of the committee's approach to stage 1 of the Commissioner for Older People Scotland Bill. Are we all agreed? Yeah, thank you. Agenda item 6 is consideration of a briefing from the Workers' Support Centre on temporary and tied visas. Are we all agreed? Thank you. Our third agenda item this morning is to hold an evidence session on the non-implementation of parts of specific acts of the Scottish Parliament. Those acts are the Domestic Abuse Protection Scotland Act 2021, the Children's Scotland Act 2020 and the Female Genital Mutilation Protection and Guidance Scotland Act 2020. This morning's session will be split into 3 with approximately half an hour on each of the acts. The committee will hear from the Minister for Victims and Community Safety in relation to the first 2 acts, and then from the Minister for Equalities on the third act. I therefore refer members to papers 1 and 2 and welcome to the meeting the Minister for Victims and Community Safety to discuss firstly the Domestic Abuse Protection Scotland Act 2021. The Minister is joined by Jeff Gibbons, Violence Against Women and Girls Unit Head, and Matt Elsby, Deputy Director, Fiscal Policy and Constitution, Scottish Government. You're all very welcome this morning. I would now like to invite the Minister to make a short opening statement, please.
Thank you very much, Convener, and good morning, Committee. Convener, if I could just ask, I do have an opening statement for the domestic side and also for the housing side of Part 1 and Part 2. Is that all right? Yes, okay. So thank you very much this morning for the opportunity to provide an update on Part 1 of the Domestic Abuse Protection Scotland Act 2021 and the work that has been progressed to ensure that a domestic abuse protection order scheme can be successfully introduced. As I outlined in my letter to you last week and as promised following the earlier evidence session on unimplemented legislation which was convened by this committee, my officials held a workshop with stakeholders and justice partners in March. And the focus of this workshop was to consider a range of options and to seek some level of consensus on the next steps required to commence Part 1 of the 2021 Act. Now, this was convened in response to repeated efforts to look at how to operationalise the existing legislation into a sustainable, deliverable and affordable framework with no preconceived conclusions as to what that may deliver. And I think it's important to reiterate the continued commitment of all our stakeholders to make the legislation work for the protection of those who are at risk. The feedback from that process was stark but clear. The overwhelming consensus from those who participated was that the fundamental changes were needed to the legislation in order to ensure that the aims of the Domestic Abuse Protection Order can be realised. There were serious concerns about implementing the legislation without those changes being made, and many of those concerns also extended to any attempt to pilot the legislation as it currently stands, which was an option discussed. I would note at this point that the Scottish Government has not been alone in their efforts to introduce similar measures as these, as they were first conceived during the COVID-19 period. And while the UK Government has piloted similar proposals, it hasn't been without its challenges and does not include the provisions around taking evidence from children. Colleagues in Northern Ireland have also followed our approach and have held a detailed workshop, and we await the outcome of our considerations with interest. And in response to the workshop conclusions, we have been considering how best to progress to reach a workable solution to introduce such orders, and how to ensure stakeholders are central to that process to ensure it works for people. Our first step is to establish a short life working group, which we hope will meet for the first time in September. Membership will comprise of the representatives from those organisations who attended the workshop in order to deliver a collaborative approach. This group will be tasked with navigating through possible legislative changes to deliver a workable and a sustainable model. It will also provide an opportunity to explore further the relationship between civil and criminal law in relation to domestic abuse incidents. We will use the group's findings to inform a consultation on possible changes to the legislation in early 2026, and it will be for a new government and Parliament to take forward any legislation that may be required, including the ability to pilot the legislation if that is thought to be necessary. While the further delay is regrettable, it is important that we listen to the feedback of those who supported and campaigned for the policy, and those who would be asked to bring it into practice so that the law works for people as intended. And I hope this is helpful on the domestic abuse side of things, and of course I'm happy to answer any questions. I don't know if you want me to go on to the housing side. We'll wait for that for the next stage, Convener.
Yeah. You can do that now, Minister.
Okay.
Yep.
I'll just give you a bit of background on this part 2 of the delayed legislation. So, again, thank you for the invitation to provide an update on the progress with implementation of part 2 of the Domestic Abuse Scotland Act. I understand the committee's concerns that this legislation has not yet been implemented. As we know, domestic abuse is a leading cause of women's homelessness in Scotland, and social landlords have a vital role to play in keeping tenants safe. Part 2 of the 2021 Act provides social landlords with the new ground to apply to the court for an order which, if granted, will have the effect of enabling the landlord to transfer a tenancy to a victim. This will allow landlords, rather than victims themselves, to take action in court to transfer the tenancy. Implementation of Part 2 of the 2021 Act has taken longer than anticipated, and there has been a number of challenges have been identified that we are working through with partner organisations in order to allow the provisions to operate as intended. We have, however, worked closely with Scottish courts and tribunal services on the development of appropriate court rules and changes to court forms. We've also worked with key stakeholders to develop the secondary legislation needed to bring these provisions into force, with the necessary SSIs prepared to support final implementation. Earlier this year, detailed statutory guidance for social landlords on the use of the new provisions was produced, and the draft was shared with key stakeholders for their views. This feedback has been taken on board, and an updated document is being produced, and sharing the draft guidance also brought together further concerns from Police Scotland on information sharing with social landlords, and we are working to find a solution where issues have arisen there. We're committed to ensuring that these measures are implemented as intended, and the Government will continue to work towards bringing Part 2 of the 2021 into force in December 2025, although the need to update the court rules and resolve information sharing related concerns raised by the police may affect the timetable. And I will stop there, Convener, and let you ask questions.
Thank you very much, Minister. We will now move on to questions. And I'm going to start off, you intimated a bit in your opening on part 1, and also in your letter to the committee dated on the 18th of June, you confirmed that stakeholders had identified such significant issues with Part 1 of the 2021 Act that the shared view of stakeholders and the Government is that Part 1 cannot be implemented without legislative changes requiring primary legislation. Can you set out for us in more detail, for the benefit of us here, the committee, what these various issues were?
Sure, Convener. So the workshop included representatives from COPFS, Police Scotland, CSTS, SLAB, Scottish Women's Aid, AMIS, Scottish Law Commission, and ASSIST. And what the key areas that were identified during that workshop for this specific part of the legislation was that current timescales from the DAPN to court application for DAPO is too short. The 3-month DAPO duration period, which was not considered long enough and which presents resource challenges, and a very short timescale to enable victims to engage with other support services while the DAPO is in place. Practicalities around timescales and reporting, such as operational capability and enabling sufficient time for individuals to obtain legal representation. Cross-border powers on how DAPO will operate in practice will require further liaison with other jurisdictions, and this is an area that will be new to all. Obtaining the views of the children, including who will gather the views of the children, with consideration on specific training, geographical constraints and timescale. And also another key area that was identified from the workshop was a duty of care to the victim and to the perpetrators and the families. So they were the key issues that were raised in the workshop in March.
That's very helpful. Thank you, Minister. We'll now move on to questions from Maggie Chapman, please.
Thanks very much, Karen. And good morning, Minister. Thank you for your opening remarks and answers so far. I'm interested, given the range of issues that you've just described, that folk have brought forward that would inhibit or restrict implementation, and the consultation that took place prior to the Act becoming an Act, were any of these raised then? What was the relationship between the conversations that happened before the final vote on the Act, and how were those issues dealt with at the time, if indeed they were raised?
Yes, I thank Ms Chapman for her question. I think the legislation at the time was intended to be an exceptional tool for use in situations where there'll be no other protections may be available. But it is clear from the operational agencies and stakeholders as part of the implementation planning that the expected volume of the new notices and orders would arise under the legislation, which would lead to significant operational challenges. I will maybe ask Jeff, because historically he was involved in this, and I appreciate this was probably before all of our time, but I do think that one of the things with this legislation, the main aim was to get the protections in place, but the challenge was also going to be how operationally it was going to work.
Okay,
but
thanks.
Jeff, can I bring you in?
Yes, thank you. Yeah, I think it was, as part of the discussion around the bill as it was going through, that there was recognition that there would be some operational challenges and that they would be resolved once the legislation was passed. That was acknowledged, I think, when the bill became an act, that the more difficult part was operationalising the legislation. The actual policy intent everyone was supportive was. So there were some of the issues that I think are still with us, probably raised in different contexts, and in some ways efforts to work through those over the period of time since then have not proved to be successful. So some of them are legacy issues, I suppose, in that context.
And I suppose, so this committee has just completed an inquiry into legal aid provision, and one of the challenges you raised was, victim survivors being able to access legal aid. Were those conversations happening at the time as well around what was available, where concerns had been raised, where there were geographic variations in availability, those kinds of questions?
I wasn't involved in the actual legislation at the time, but from what I've looked at, yes, there were discussions. I think it was hoped that some of those will be worked through as we look to operationalise those. I think we also, as part of the discussion in the workshop, we're looking at the opportunity to work through those as part of the pilot, but unfortunately both the provision to pilot was not including the legislation, and even if we were to pilot, the view was that we would still come up with the same issues. So we looked at options to kind of work through those operational challenges as part of the pilot lessons learned, but that didn't seem to the stakeholders to be viable based on the framework that we had. Okay.
And given the consultation that is to come, I suppose, what are the lessons that we can learn? And whoever wants to take this, what are the lessons that we can learn, given what we know about other structures that need to connect to this, whether it's legal aid provision, whether it's the training and support for taking evidence from children, those kinds of things. What can we learn from from the process to make sure that we're not here in another year or two having asked for more information, got more information, made promises to people and still not being able to deliver DAPOs?
Yes, so I think when this legislation, and we do know that it went at pace because it was during COVID time, even though it was just to try and get protections up in order, and then obviously we're dealing with the aftermath. I think there are lessons that because I'll go on to it further down with some other things that are happening at the stage of maybe stage 3 amendments coming in, but there's not the background of work gone into the operational way, and then they get passed. Then that could add delay to us trying to implement it, because then we're trying to do the work of the amendments that were passed. So I think there's lots of lessons to be learnt. I don't know if there's anything, Jeff, that you can, from that specific legislation that went through during that time.
I think from the process, I think the focus on trying to operationalise and trying to find different solutions kind of took our eye away potentially from looking at legislation at first principles and what the challenges might be from there. So the commitment from all the stakeholders has always been to bring life to the legislation. Taking a step back, looking at legislation in the first instance, we might have been able to unravel that, or maybe that was become clearer. But I think I think the process has always been the pace of legislation, engaging the policy intent with the operationalisation of that, and bringing stakeholders in and working that through perhaps a bit earlier if we could. But as the Minister said, the pace of the legislation and the commitment from everybody to see it through, I think that probably overrided the kind of broader challenges of bringing it to life. And also I think, frankly, the cost involved in the legislation as well, and how that would fit into making it sustainable.
Can I just clarify the cost involved in implementation for partner agencies like the courts,
Yes,
police, or
yes.
all of them?
Yes.
Okay.
So
okay.
making sure that was sustainable from the outset.
That's helpful. Can I move on to part 2? I've just got a question on part 2 then. And I suppose you previously stated, Minister, that the aim was to lay relevant secondary legislation in the summer and bring it into force later this year, in December or over winter. Can you update us on exactly when this will happen? What are the timescales for that part 2?
Yes, so I think, Ms Chapman, what we're working towards implementation of part 2, and it is now well progressed. I will bring in Matt in one moment, but as I said in my opening speech, or second opening speech, is the target is to bring these provisions into force by 2025, and that's what we're aiming to do. So although there could be court rules that may affect the timetable, but that's what we are aiming to do, December 2025. I don't know, Matt, if there's anything further you'd like to add.
Yeah, that's right. So we're working towards December 2025. But one critical outstanding issue is around data sharing and making sure that we have a clear understanding with Police Scotland around what data can be shared between Police Scotland and social landlords.
So that's helpful. And I suppose one of the other questions I have as you were speaking, Minister, was thinking of the relationship between criminal and civil processes here. There's other legislation going through Parliament at the moment, other discussions happening that kind of relate to, if not directly speak to this issue of how civil and criminal courts might be able to work together. Can you just say a little bit more about that? Because I think with the criminal justice modernisation legislation that's going through, the victims' witness justice reform legislation, there's an opportunity for us to make sure we get this right. And I want to make I just want some reassurance, I suppose, that as you're working through part 2 implementation, that you've got your eyes on what's going on elsewhere as well.
Yeah, absolutely. And I think I'll bring in officials if they can add anything to that, but I think it's vitally important. I don't know if you're aware of the work that the Scottish Law Commission's currently doing as well. So, yeah, that all adds into how we move forward with it all. I don't know if there's anything that Jeff or Matt want to add. No?
Only to add that clearly the Scottish Law Commission have been part of our workshop, and that's been part of the referring to your earlier discussion, part of the challenges about how we address the ongoing sort of challenges around civil and criminal, and how that works for our justice partners. So that's very much on our radar, and part of our workshop is not just looking at this legislation, but that kind of broader context as well.
Okay. Because it would be a shame to get all the data sharing issues sorted out, only to come to find, oh, we didn't think of this. Yeah. So, yeah, you're thinking about that too. Yeah. Thank you. I'll leave it there. Okay.
Thank you. We now have a question from Marie McNair, please, who's joining us online.
Thank you, Convener. Good morning, Minister, and your officials. I mean, it is extremely disappointing about the delay in the implementation of Part 1. And obviously, you know, we've heard the concerns about how easy it is to, or not easy it is to access legal aid. Do you think the delay in the implementation of Part 1 strengthens the policy case for making legal aid a bit more available for the civil protection orders?
Yes, and I thank Ms McNair for that question. I think I know that your committee has just recently finished your evidence session on civil legal aid, so I am looking forward to your report and your recommendations from that. I think there is scope for consideration, but as I said in my evidence session previously, I do have some concerns about removing means tests in this specific area. Obviously, there's going to be a cost to the public purse, but to ensure equality as well, we might need to give automatic legal aid to the defender and the person who is alleged to causing harm, as well as to the applicant. So it's quite a complex area, and I am open to suggestions on how we move forward, but it's something worth considering.
Thanks for that. Cheers.
Okay, thank you. Do any other members wish to come in? No, that concludes our first session this morning. We will now suspend briefly for a changeover of government officials. Thank you.
Thank you.
I would now like to move on to our discussion of the Children's Scotland Act 2020, and we're again joined by the Minister for Victims and Community Safety. For this item, however, the Minister is supported by Simon Stockwell, Family Law Unit Head, Scottish Government. You're very welcome this morning, and I would like to invite the Minister to make a short opening statement.
Thank you very much, Convener, and I'm grateful to have the opportunity to outline our approach in relation to the implementation of the Children's Scotland Act 2020. As I set out our plans in my letter of the 11th of March to you, Convener, we remain committed to implementing the 2020 Act in full. To date, the Scottish Government has made 3 sets of commencement regulations in relation to the 2020 Act. The most recent set will commence provisions to amend requirements when a parent or another person with parental responsibilities and rights is making a major decision about a child's life, and this will commence on the 21st of September this year. These regulations also commenced, as of 2 days ago, provisions which require a court, when considering a child's welfare in a range of proceedings, to consider whether any delay in these proceedings would negatively affect the child. We will also lay SSIs in September this year to bring in regulation for the child contact centres, laying as soon as we can to provide clarity on how the regulation will work. And as we lay a further commencement SSI later this year, this will cover a number of areas. So we're looking at laying these SSIs in October 2025. The remainder of Section 1 of the 2020 Act on the views of children in court cases in areas such as child contact, Sections 2 and 3 on views of children in relation to adoption and permanence proceedings and children's hearing proceedings, Section 16 on factors for the courts to consider before making an order on matters such as child contact or residence, and Section 18 on duty on the courts to consider the best interests when allowing access to information, and Section 32 on delay in relation to child contact and residence cases. There is still more work to be done. For example, the planned register of child welfare reporters is a key provision of the 2020 Act. Child welfare reporters can play a key role in contact and residence cases, providing reports to the sheriff, hearing the case and interviewing key people, including the child who will be at the centre of the case. So we've re-established a child welfare reporter working group, and this will look back at changes made in the past, but it was also going to look forward to the future and to implementation of the register. I hope that brief introduction reassures you, Convener and Committee, that implementation of the 2020 Act is taking place and continues to take place, and we recognise the need to implement legislation, and the 2020 Act is particularly important given it is about children, and I'm happy to answer any questions.
Thank you, Minister. We'll now move on to questions. And just to start off, Minister, thank you for updating us on the months that we can expect the set of regulations. In terms of when the two sets of regulations will then take effect, are the lead-in times stated in that March 2025 letter, that it's 12 months and 18 months respectively? Is that still correct?
I will get Simon to confirm, but my understanding is the SSIs that I've just said in my opening speech, section 1, 2, 3, 16, 18 and 13, we will lay them in October this year, and they will come into effect in October 2026. But with the Child Contact Centre SSIs, the time, lead-in time for that will be a little bit longer, on 18 months. But Simon...
That's correct.
Yes, that's correct.
That's great. Thank you very much. We now have a question from Paul O'Kane, please.
Thank you, Convener, and good morning to the Minister and to Mr Stockwell. Given the policy criticisms of the lack of regulation of child welfare reporters and the implementation of the regulatory regime which was proposed for these reporters, I think the regulation of that seems important in terms of how that will be carried out. So does the Government intend to implement that regime for child welfare reporters in this parliamentary session or in the next one? And if it is going to go into the next session, is there a best estimate as to when that's going to happen and come into effect?
Yes, so the Scottish Government recognises that establishing the Register of Welfare Reporters is one of the key provisions in this legislation. It is something, as I said in my opening speech, we've established the working group and looking at what changes can be made and how we establish a register. The register will not be in this parliamentary term. There's no time for legislation-wide, so just have to be 100% honest. We are aiming towards going forward with that, but I would envisage that it would be implemented in the next parliamentary term. I don't know if Simon would be in a position, because it would be up to whoever's in administration the priority of that. So that's where we are at the moment. We are working on it, and we recognise the importance of it, but we won't be in a position to do it this parliamentary term.
I wonder if, just in terms of, I suppose, then the legacy from this parliamentary session in terms of regulation that will be held over into the next Parliament, and I think the Minister's right in terms of we've got to go through an election and a government formation. But I mean, do officials have that in terms of, do they have a view of a timescale?
Well, I'll ask Simon. I think there's a lot in this bill, not a lot, but there's still a lot of work to be done. Some of the amendments that were put forward, as I was sort of relaying to it earlier on, that we still have to work through. I might ask Simon, realistically, if we move into next term and it is a priority for the next government, what kind of timescale do you envisage we'd be looking at to implementation of the child welfare register, for example?
Thank you, Minister. I would think 2 to 3 years. We will need, for example, to contract out the day-to-day operation of the register. We have the option of running it in-house with more civil servants doing it, but I think the logic will be to contract it out, and that will take probably a year or so to go through the tendering exercise, and there'll also be a need for the contractor to gear up. There'll be a need for the incoming administration to make some regulations to determine things like what criteria do child welfare reporters need to have to be on the register. There'll be a need to lay down exactly what training a child welfare reporter needs to have. And then there'll be a recruitment exercise to ensure that we get lawyers and other professionals to move on to the register as well. So a year plus to carry out the tendering of the operation of the register, and a year plus to actually recruit people onto the register. And there probably will be a need for some court rules as well. That can be done roughly at the same time. So 2 to 3 years, I would say.
Okay. I'm very grateful. That's very useful, and I think useful to this committee in terms of its legacy report and passing on to whoever comes next. I wonder if I can just, on another question around some of the amendments that were in the bill. Obviously, there were a number of non-government amendments that passed, which brought in various provisions, not least on child advocacy services, which were section 21 of the bill, alternative dispute resolutions in sections 23 and 24. And obviously, at the moment, we don't have a plan around implementation of those. So I think it would be useful if the government could place on record its policy intention to implement those relevant provisions. And again, I appreciate probably not this parliamentary session, but the next one.
Yeah, absolutely. So just we'll start with the alternative dispute resolution. So we support the ADR, including mediation in the child contact centres, and already the Scottish Government does provide funding for Relationships Scotland and their network to provide family mediation services already. So we have not yet implemented the two provisions of ADR in the 2020 Act. Section 23 on funding the ADR in child contact and resident causes will require a good deal of thought. Given other pressures, Section 23 has not been a priority, but we will implement this in time. And Section 24 is a pilot scheme for information meetings on alternative dispute resolutions. And this is more of a priority, and indeed lessons from the pilot will inform how we do the work on Section 23. However, there's still a fair bit of work to be done in relation to Section 24. If I could just move on to child advocacy, which was part, I think it was an amendment prior all our time here. But this provision represents major investment, and it will be significant support for children who are at the centre of child contact and residence cases. So we are discussing with key bodies what they would like to see in this area, and there are a number of points to consider with this as well. Is what exactly should the role be? We assume explaining to the child what the process involves and helping the child give their views as required. How to ensure this role does not cut across the role of any trusted adult that the child has or any other support services that the child has. How to ensure the advocate is fully trained. How to provide children with information on the service, and how many cases can an advocate take on realistically. So working with other adults who may be involved in the case, e.g. the parents themselves, any other support workers, any support from the third sector bodies, whether legal or practical, any curator appointed by the court, and any child welfare reporter appointed by the court. So there is work ongoing, and these are the considerations that we will look into as we make progress on this specific area. But it's quite complex and a lot of things that work to be done in there.
Okay, thank you, Convener.
Thank you. Do any members wish to comment on any other questions? No. That concludes our discussion on this Act. Thank you, Minister and Official, for coming along this morning. We are now going to suspend briefly for a changeover of Ministers and Officials. Thank you. I would now like to welcome the Minister for Equalities to discuss the Female Genital Mutilation Protection and Guidance Scotland Act 2020. The Minister is joined by Nell Whiting, Violence Against Women and Girls Team Leader, Scottish Government. You're both very welcome this morning. I would now like to invite the Minister to make a short opening statement, please.
Thank you, Convener. I'm very grateful to the committee for the invitation to provide information on the work being undertaken to implement the Female Genital Mutilation Protection and Guidance Scotland Act 2020. I want to begin by stressing this government is resolute in its commitment to the implementation of legislation passed by this Parliament. As the Minister for Parliamentary Business highlighted when he attended this committee in December 2024, work involved in implementation can be complex. It also relies on other organisations and agencies that we need to work with. Hence, to ensure the effective implementation of the Act, we are working closely with external stakeholders, including Police Scotland, Scottish Courts and Tribunal Services, local authorities and health representatives, as well as our Addressing Violence Against Minority Ethnic Women and Girls network. We aim to implement the Act within 2026. However, this timeline is dependent on other organisations' capacity to implement as well. I am clear that whilst I want this Act implemented as soon as possible, we will be implementing in a way that is sustainable, which ensures that the Act can deliver the protections to women and girls intended without placing unmanageable pressure on those responsible for delivering. Work underway falls into three main development areas: court rules, statutory guidance, training and awareness raising. I will raise each of these in turn. Court rules are necessary to provide clarity about how the Act will work in practice and what procedures need to be followed to ensure that the legal processes remain effective and efficient. In the case of the FGM Act, court rules might be needed to provide clarity on issues such as timescales for carrying out procedural steps, how the views of child victims or witnesses will be sought and by whom, what forms are used to gather information and how this is stored, how anonymity is maintained, where and how removed passports may be stored. An additional complexity in this case is that both criminal and civil court proceedings will be needed. We have spoken with operational partners and have agreed to establish a legislative working group to ensure that all relevant partners are brought together to work through these issues. The creation of statutory guidance will help to address knowledge gaps and offer clarity and certainty for practitioners and organisations working with victims of FGM. Officials have set up a statutory guidance working group, which includes representation from health, social work, education, child protection, Police Scotland, Children's Hearing Scotland and the Scottish Children's Reporter Administration and third sector organisations. The working group has had 2 meetings, one of which was held yesterday. As a result, the content, structure and overarching aims of the statutory guidance has been agreed. Officials will be drafting the statutory guidance over the summer of 2025 with the intention of circulating a draft version to stakeholders for feedback later in 2025. We've also agreed with the group the production of sector-specific pamphlets. These will be concise and accessible resources for professionals to use in their day-to-day practice. A similar approach was taken when we refreshed the statutory forced marriage guidance and it was received well. Finally, I'd like to highlight work related to training and awareness-raising materials. Officials are currently undertaking a mapping exercise to identify existing training across sectors such as education, health and policing. This will help us to understand where the gaps and opportunities lie, and once complete, officials will engage stakeholders to co-design appropriate training solutions. In regards to awareness-raising materials, we understand that these will need to be culturally appropriate, available in multiple languages and produced in inclusive formats to ensure accessibility for all. We recognise that community-based awareness is crucial, and we will work closely with stakeholders to ensure this is a core element of our approach. So, in conclusion, Convener, I hope the committee can see that real progress is being made towards implementation, and I am happy to take any questions from the committee.
Thank you, Minister. We will now move on to those questions, and I'm going to start us off. Minister, the letter of the 11th of March 2025 that you sent said that legal and technical changes might be required for implementation of the Act. Could you tell us a bit more about what these legal and technical changes are and what might their impact be in terms of implementing the Act?
Thank you for that. So I think that we're talking about the court rules, and court rules are a type of secondary legislation which set out the practice and procedures of the courts. They provide clarity about how the Act works in practice and what procedures need to be followed to ensure that the legal processes remain consistent and efficient. The Scottish Civil Justice Council considers and prepares draft rules of procedure for the Scottish civil courts. When approved by the Council, draft rules are submitted to the Court of Session for consideration, and if approved by the Court, an Act of Sederant is made. And in the case of this Act, court rules might be needed to provide clarity on issues such as timescales for carrying out procedural steps in a case, how the views of child victims and witnesses might be sought and by whom and what forms are used to gather that information, and of course how that information is stored. Also how anonymity can be maintained, and how removed passports might also be stored. And, of course, a further complexity is that the Act allows for the FGM protection orders to be issued in both the civil and in criminal proceedings. So, during criminal proceedings, courts may impose a protection order following a conviction for an FGM offence, and this represents challenges with implementation, as civil and criminal proceedings have different procedures and they have distinct IT systems as well. So careful consideration is required to ensure that implementation is effective in both courts of that. And we do anticipate that implementation, the rules will require systems change and associated costs across the justice agencies.
Okay. Thank you. We now have a question from Marie McNair, who's joined us online.
Thank you.
Thank you, Convener. Convener, my line of questions has been covered in the Minister's opening contribution.
Okay, thank you. Would any other members wish to ask a question? Maggie Chapman, please.
Thanks very much, Convener. Good morning, Minister. Thank you for being here this morning. Can I just dig a little bit deeper to some of the things you've already said? Just there, you talked about the legal and technical changes, including sorting out different procedures and distinct IT systems between criminal and civil courts. I'm wondering how many of these challenges were discussed or excavated at earlier stages prior to passage of the Act and it achieving royal assent, because it does seem that some of those challenges should have been obvious, and what work was done to understand the scope of the challenge and how they would actually be dealt with. You know, why is it that we're only implementing, only dealing with working groups now, type thing?
Yeah, no, thank you for that question. I mean, you'll be aware that the Act was 2020, so if it's all right, I'm going to bring in Nell on that point. Thank you.
Thanks, Minister. How much was understood? We can go back and have a look at the various kind of processes that went through. I'm aware that there were changes throughout, amendments and so on and so forth. Some of those amendments were quite late, so we're dealing with those now. What I would say is whenever a complex piece of legislation is implemented, obviously great minds get together and try to iron things out as soon as possible. There are always snags in the process, so this Act is no different to the other two that you heard about and any other legislation, but can certainly get back to you and have a look at what process was taken during the passage of the bill, if that would be helpful.
I suppose what I'm trying to get at is, what is it that we need to guard against for future legislation, or even for some of the implementation of this, that so we don't end up. Minister, I heard your commitment. You know, you want this implemented soon, but how can we be sure that we don't come across the same kind of issues in this or other similarly complex and quite sensitive laws that we might wish to enact?
Yeah, I think from my sort of like perspective you know, my awareness raising that has happened while I've been in post, I think that, you know, it's sort of like, it's difficult to preempt everything, especially when you've got legislation that cuts across other legislations and it cuts across many other domains. For instance, child protection comes under this as well. You're then dealing with multiple organisations. Bringing people together always takes time. I mean, it can be done quickly, but I always think that if, you know, for something like this, in order for it to be implemented consistently and to be done well, then ironing it out does take time. And I am aware that when the Minister for Parliamentary Business came in December, and I would also accept that, you know, there have been disruptions in, you know, there's been delays, and that, you know, is not something that we would have wanted, and he outlined very clearly, you know, some of the reasons for that delay. So in that sense, I understand that, Ms Chapman, that it has taken time, but I think we need to keep that in perspective, that whilst there are complexities of bringing together many agencies, and as I said, the implementation of this is not just within the Scottish Government's gift, it is, you know, many other people have responsibilities, and we need to make sure that everybody works together in step. But, you know, there were clearly reasons for the delay. You know, many things got caught up during COVID, and that was well rehearsed last time, so I won't go into that any further. So yes, there has been a delay, but that delay is not entirely to do with the work. And certainly, I hope that, you know, I have demonstrated that has been clear progress that has been made since you last took evidence on getting an update in December.
Thank you. And I mean, I heard quite clearly the work that's going on, I suppose, particularly around the statutory guidance, that cross agency work, you know, pulling people in from a whole range of different organisations, agencies and beyond. I was interested, and maybe I missed it, but given some of the engagement around children's rights, and obviously UNCRC is still a very, very new and live thing. What engagement, or is this Children and Young People's Commissioner, has she and her office been involved in some of these discussions? Because I think what I want to ensure is I want to hear reassurance, I suppose, is that we're not reinventing the wheel. If there are good conversations that are happening already, can we learn from those without replicating things and so speed up implementation?
Yeah, absolutely. As you say, the statutory guidance describes the responsibilities of chief executives, directors, senior managers in agencies that handle cases of FGM. The guidance will also set referral pathways with the aim of improving that collaboration between statutory and specialist services to make sure that victims receive the support that they need. Officials have set up the Statutory Guidance Working Group, which includes representatives from health, social work, education, child protection, Police Scotland and third sector organisations. I can get a confirmation from Nell whether the Children's Commissioner was involved. In order to ensure close links with the Children's Hearing System, representatives also includes the Children's Hearing Scotland and the Scotland's Children's Reporter Administration as well. I don't know for a fact whether the Children's Commissioner was involved.
We don't have the Children's Commissioner involved in that working group because it is a working group of people who will be able to advise as to practical issues and, you know, what do social workers need to think about, what do the police need to think about, what does the Scottish reporters, what do they need to think about. So I think we've got the right people around the table for that. We can certainly undertake to share the draft guidance with the Children's Commissioner, to get that feedback. That would be really helpful. But I think that what we have around, or those that we have around the table, are the right people. We're confident.
That's really helpful, Nell, and I think just having those eyes on that draft might be helpful and might spot things that might cause issues later on. My final question on this is around the training and awareness, and I suppose how conversations have gone with bodies that have responsibility for training healthcare professionals, social work professionals, because there's something about training, as you identified, the culturally sensitive and community-based awareness is crucial. But if our professionals across the wide range of agencies that could and should be aware of this, if that's not what it should be, then we're not necessarily going to get the support to the people who need it at the right time. So how have those conversations with the people who train the professionals who will be in a position to support or to identify, to notice sometimes?
Yeah, no, you make a really, really good point there. And officials, as I mentioned in my opening remarks, are currently undertaking a mapping exercise to identify the existing training across sectors, such as education, health and policing. And that then enables us to identify gaps and also where the opportunities are. And once complete, officials will then engage stakeholders to co-design appropriate training solutions. And I think that is essential, that they are co-designed, that we're hearing from the very people who have experience of this, whether that be, through victims or supporting or providing services. So to make sure we've got that joined up approach. And it's one of the reasons that it's taken, a bit of time in order to do this, but we're determined to do it well and to make sure that it is sustainable in that sense. The training materials and, of course, the awareness raising materials will be developed for both professional sector and for the wider public as well, because there is there's an education and an awareness raising piece amongst society, really. And the materials will be culturally appropriate and, as I said, available in multiple languages, and we'll make sure that they are inclusive formats to make sure that they are accessible to everybody. We're also, officials are also exploring the option of organising an event to mark International Day of Zero Tolerance for FGM in February 2026 to further raise that awareness. So that's an example of not only within the sectors and within the communities, but also with civic society at large. I also sort of alluded to the materials being developed with our sort of like group that we have, the advisory group on sort of like women and girls of ethnic minority women, drawing on their expertise to make sure that the content is appropriate, accurate and, of course, targeted. Now, the development, I hope I can give you some reassurance that we're well on the way to that. The development of these materials will begin in late summer to autumn 2025. So I think I'm establishing a timeline for you over the next year, because we are absolutely on track for implementation in 2026.
Thanks, Minister. That's helpful. And I suppose just my final point on some of that training and awareness, it can't be a one-off event. It has to be ongoing. It has to be embedded in and become part of the professional training and possibly even accreditation that different professionals go through to practice. And I think we probably all need to just bear that in mind, that it's not a one-off event.
Yeah.
Implementation of the Act might happen, but that ongoing training is really, really important.
Yeah, absolutely. And I mean, certainly sort of, experience from England and Wales shows us that increased awareness and training amongst professionals led to a rise in applications for the FGM protection orders. And I think that's a clear demonstration of highlighting how effective awareness raising and training as part of implementation is.
Okay, thanks. I'll leave it there.
Thank you. We have a question from Tess White, who's joining us remotely.
Thank you.
Thank you, Convener, and good morning, Minister. I've just got a couple of questions for you, if I may. So the Women's Support Project, in their response to the committee, talked about the delay in refreshing the national FGM guidance and implementing the Act. And they mentioned the perception of a lack of capacity in the Scottish Government Equalities team. So my question, Minister, are you satisfied that you have the resources within the Scottish Government Equalities team to deliver progress on this?
Thank you for that question. Just to clarify, it's not a refreshing of guidance, it's the statutory guidance that we are developing. Yes, I am. I did note with interest the previous evidence session in December, and I was very careful to track the progress that we have made in the last 6 months, and I am satisfied that we are on course to deliver this within 2026, because I absolutely take on board that there are legitimate reasons for the delay. However, that delay is having an impact. We cannot have that. Women are suffering, and we need to make sure that we do everything we can. So absolutely, I can assure the committee that I am satisfied that we are absolutely on course.
Thank you, Minister. My second question is the Alnisa service, which you're familiar with that service for women and girls across NHS Lothian who've had FGM, reported a 50% increase in FGM cases in 2023. So they'll be watching today. Just if you've got any messages for the Women's Support Project and for organisations like the Alnisa service, particularly those that are massively concerned that the Act hasn't been implemented yet.
I'm sorry, could you just repeat the last bit of that question? I'm afraid I am a little bit hard of hearing.
Yes, sorry, Minister. Just your message to the women like the Women's Support Project and the Alnisa service. What's your message to them with their concerns? And as I said, I mentioned the 50% increase in FGM cases in 2023 from the Alnisa service. What's your message to them about your personal commitment to delivering the required changes? Thank you.
Yeah, thank you for that question. So I would like to say that I am very grateful to the ANISA service because they are actually working with us. So we as a government are benefiting from their experience and the knowledge and expertise that they have to offer. So I would like to give the committee reassurance that we are listening very, very carefully to their opinions and we are working with them and we will continue to do so.
Thank you, Minister. Back to you, Convener.
Thank you. Are members content that they've asked everything they wish to? Yes. Well, thank you. That concludes our evidence taken. The committee will now reflect on the evidence and then we will consider our next steps. So that concludes our formal business in public this morning. I once again thank the Minister and our official for joining us. We will now move into private session to consider the remaining items on our agenda. Thank you.